Before we jump into the first hearing, let me set the stage, because what you're about to see is one of the clearest demonstrations of how fragile probable cause can be when a judge is actually paying attention. Harris County sees thousands of misdemeanor assault and interference cases every year, but only a small fraction get scrutinized this closely. Judge Fleischer isn't just reviewing paperwork. He's dissecting the state's logic piece by piece, checking whether the allegations actually meet the law's requirements instead of simply rubber-stamping charges. And in today's episode, every case represents a different kind of legal tension. You'll see police assumptions challenged, gaps in affidavits exposed, and prosecutors scrambling to justify elements that just aren't there. Some cases crumble because the evidence contradicts itself. Others fall apart because the state overlooked a basic statutory requirement. And in at least one case, the judge has to remind everyone that chaos, especially during medical emergencies, is not the same thing as criminal conduct. As you watch these hearings unfold, pay close attention to what triggers Judge Fleischer's hesitation. Is it missing testimony? An officer's assumption? A lack of clarity in video evidence? Or simply an element of the offense that the state never properly addressed? This episode offers a rare, unfiltered look at what it really means for the state to meet its burden before a case ever goes to trial. And trust me, by the time we reach the end, you're going to find yourself asking, how many cases move forward every day without ever getting this level of scrutiny? Let us know what you think as we dive into case number 1.
Sorry, Mr. Pons, I'm just...
The affidavit in that she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that...
you. That's why I'm up here challenging the PC on that one. The officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him as well.
But you said that you did feel pain.
Reread the complete dim.
I wouldn't, or that's the problem, is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about, that the officer filed with the complaint.
So the complete dims reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training and experience, I know being grabbed and bruises being left on her body causes pain. So according to the full dims, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full dim states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress and excitement, so you're not feeling it. But then after...
That's not what she said, though, or that's not what
stress
going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing, and then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
That's not in that.
But the officer never asked, hey, do you feel pain? Why wouldn't you
The
ask?
officer never asked. He came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that connection.
You don't operate on hunches.
Right. And she's also stated that I was fighting him. So that could be because of her fighting.
I mean, here's the deal. Like if I find no PC, right, they may just re-indict it though.
That's fine.
No.
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time, she doesn't feel pain. But after a while, he assumes that she feels pain because of bruising on her arm.
And on body-worn camera, he never says, we don't know.
But well, I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do, though, right.
Well, if there were visible injuries, we can go from there.
But he's saying that, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, do
You
it
know?
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if you
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's what I'm saying.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. And if we want to re-indict it, we can.
Okay, all right, I'll find no PC.
This first ruling sets a powerful tone for the rest of the docket. What we just saw wasn't a judge being lenient. It was a judge enforcing the law exactly as written. Assault bodily injury in Texas requires proof of pain, and the state's own affidavit said the complainant didn't feel any. That's not a minor detail. That's the element. Without it, there is no crime. And notice how the judge didn't just rely on the defense argument. He dug into the affidavit line by line. The state tried to patch the gaps using the officer's training and experience, but training isn't evidence. Pain has to come from the complainant, not from an officer's assumption. What do you think? Should bruising automatically count as pain? Or should prosecutors be required to prove what the law says they must prove, even when emotions are high? Drop your thoughts below because this isn't just a legal technicality. This ruling is a reminder that probable cause requires facts, not guesswork. And as we move into the second case, involving alleged interference at a university, you'll see that the line between lawful police orders and overreach can get very blurry very fast.
You're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On September 26, 2024, at approximately 1:15 p.m., an officer responded to a call at the TSU Library Center located at 3100 Claiborne Street in Harris County, Texas, regarding a disturbance. The officer made contact with the individual causing the disturbance, and the defendant approached asking officers what's going on and what did she do. The officers repeatedly asked the defendant to step back, and she became belligerent, asserting that they were at her store. She eventually complied and moved away, but she insisted that a police supervisor be called to the scene. TSU Sergeant Barnett arrived and spoke privately with the defendant. Afterwards, responding officer requested the defendant's information to report her behavior to her supervisor in the university. The defendant refused to provide it and attempted to bypass the officer. When the officer asked her to identify herself again, the defendant declined and attempted to walk away. As the officer tried to detain her, she began to throw herself on the ground and yell, escalating the disturbance. Several officers issued verbal commands for her to comply. The defendant continued to resist, jumping around and asserting her rights. The officer attempted to escort her outside. The defendant then wrapped her arms and legs around a pole, continuing to yell. The officers physically pried her from the pole and detained her. The defendant used her body weight to resist and push against the officers. The defendant was then placed in the back of the patrol car without incident.
What's she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation, she refused.
You didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess,
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking
See,
the
right.
officers.
So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave. And then they start asking her for her information.
Well, they were asking her to leave the scene so that they can respond to the disturbance, and she wouldn't comply. I think that's the issue, that she wouldn't leave when
Did
they asked her.
you say that?
Yes. They asked her to move away from the scene and she refused to comply.
Show me, will you read that part again?
So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, but
So she complies, she moves away,
right. But then she came back.
okay?
And so at that point, when she returned, they asked her to identify herself. She refused to provide her identification. And then at that point, when they asked her to identify herself, she attempted to bypass the officers.
She leaves, she's trying to leave.
She is attempting to, yeah, she's
Leaving.
attempting to leave again.
And then they start bucking up to her.
Sure, yeah.
Judge, what is this case?
It's on for tomorrow's docket. Let me give you the cause number. 251-1137.
Sounds like an interference.
That's what she's charged with. But, so, sounds like she's got a case of the nosies, you know? She goes up there allegedly being nosy, leaves, comes back, and then they start asking for her information. And she declines to give her information.
So Judge, what I'm looking at here, just to add context to the situation, she approaches in an unrelated incident, it looks like.
Correct.
She's asking what's going on. Fine. They talk to her individually. Okay. They tell her to leave. She continually asks what's going on. What did she do? She asserts, she becomes belligerent, is what the officer says, asserting that they were at her store, obstructing their investigation. Eventually, I don't know what the time frame is, but they say eventually she complies, moves away, but insisted that they need to call a supervisor to the area. A sergeant then spoke with her privately. After they responded and they requested her information to report her behavior to her supervisor at the university, and to identify her, which she refused to do. She then attempts to bypass officers. They ask her for identification again. They're detaining her. She says no.
But what's the interference? What did she specifically do?
Well,
She's just talking to them.
I understand,
Right.
Judge. She's talking to them, but she's saying that they're at her store. She's belligerent,
So?
telling them to leave. They're at her store. The position of the state judge is that did obstruct their investigation. I mean, it's not in this. There's multiple senses of obstruction in our opinion. It's not.
Are you losing right now? Okay. Yeah, I'm not.
What ties all of these hearings together is the judge's consistent insistence on statutory precision. Whether it was the missing pain element in the assault case, the lack of actual interference in the Winbush proceeding, or the absence of criminal negligence in the Kemp EMS incident, Judge Fleischer examined each allegation through the exact wording of Texas law. Not the assumptions, not the emotions, but the elements. These decisions aren't just procedural victories for the defendants. They're constitutional guardrails preventing the state from moving forward without meeting the threshold required by the Fourth Amendment. This is the justice system working the way it's supposed to, with the judge acting as a gatekeeper to ensure that prosecutions begin with real, legally valid evidence. So as you reflect on these cases, consider how many charges in other courts might collapse under similar scrutiny. Did the judge get it right? Would you have dismissed these cases too? And which ruling surprised you the most? Tell us in the comments. We love hearing your perspectives. And if you found these breakdowns as eye-opening as we did, make sure to hit that like button, share this video with someone who loves legal analysis, and don't forget to subscribe for more jaw-dropping courtroom breakdowns every week.
So what's the word, Thunderbird?
So upon watching the video, I agree with the offense, but it's not really clear. It's all happening at once, where you see one moment the defendant like lunge forward but blocked. You can't see what he does, and then officers grab him immediately. So you really can't see the grab that the officer says in the OR that occurred. But in the OR, it says there was that grab, and that's why they grabbed him back. So
It's not there, it's not there.
Not there.
you just can't see. It's not saying it's not there. It's just that you can't see it on video. It's obscure. There's people in the way because
So I guess my theory from reading the notes is that when the whole situation was happening with his mother, the gurney was left
outside of the house. So the EMS never came inside the house. They were asking the son who opened the door the mother has to walk outside. And he was like, my mother can't walk outside because she's having trouble breathing. Mom eventually comes outside, gets on the stretcher. The stretcher is then taken into the ambulance. The son is running after the stretcher because they're trying to make sure that their mom is fine. What the commotion that arises is that, for me, I feel like nobody knew who exactly pushed who, but it's more of an emergency situation about a child caring for his mom who's having a serious medical issue.
I mean, times like this, when you have a medical emergency, right, it's always chaos. I mean, there's chaos ensues, right? Is he really trying to prevent an EMS person from doing their job?
See, look at the totality of the facts. It's like, how are you supposed to, how is he trying to prevent someone from doing their job when all he's trying to do is make sure that he's helping his mother, who they said, hey, we're not going to come to the house to even bring you in.
Did he pull the arm off?
According to the officer, he just grabbed it and the officer grabbed him at that point. So the reason why it's not really clear how quick it happened. On the video, it looks pretty quick because the officers grabbed him immediately.
But the issue is that the officers arrive at the scene when there is already an incident occurring. They don't know, the officer can't state what happened initially.
Right, but the issue here is that as it's played, it's like the grab of the arm is that interruption or just disruption of the EMS trying to get the mother onto the gurney. And it's not necessary that the defendant intended to do that. It's just that there was that
This is
disruption.
a specific intent crime, so he has to specifically intend to interfere with the duty of that person, of the performance and exercise of what the official is trying to do. That's what he's charged with, right?
Respectfully, this is like criminal negligence. There's no intentionally knowingly requirement for this. It's just that a disruption occurred through the defendant's actions with criminal negligence. So in this case, he grabbed the EMS and the negligence would be that a reasonable person should have known not to do that, and that therefore resulted in the disruption of the EMS trying to perform their duty.
But the negligence also didn't pose a serious harm or threat. Like the EMS didn't appear to be threatened. I just don't think it's enough. I mean, even if they were to give us an offer, if we take this case literally to trial, the mom is going to testify as to what happened, including the brother and the dad, because they were also witnesses, which I spoke to all of them. I mean, I'm saying are we going to drag it? Because I just don't see it.
Our position would be that there's enough to move the case forward with probable cause. Whether there's issues for trial is another issue.
I mean, in that sense, he's right. I mean,
Yeah.
it's just a probable cause hearing. Is there enough to move forward? Because it's a very low burden, right? Yes, I agree with you. Is it enough to find someone beyond a reasonable doubt guilty? Perhaps not.
And I'm also basing my arguments as what is actually the evidence that we currently have to kind of figure out the confusion on what actually happened that night. Because the videos are not clear at all, which sucks.
Videos are not clear, so admittedly, our reliance is on the sworn statement by the officer in the DIMS.
So let's look up, because it says here, by grabbing EMS responders' right arm, interrupt, disrupt, impede, and interfere with Sanders, a person employed to provide emergency medical services, including the transportation. I'm sorry, this is what I'm looking at. Did then and there unlawfully with criminal negligence. What does criminal negligence mean? Let's look it up.
Yes, Judge.
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm in this case?
One moment, Your Honor.
The risk must be so significant that it's a gross deviation from what a reasonable person would do.
I mean, I'm going to argue that if he was briefly grabbing the responder's arm, it does not create substantial or unjustifiable risk of harm. Meaning the fact that due to the nature of the situation, he was acting emotionally.
And Your Honor, if we're going to go that, I'd respectfully ask for maybe 5 minutes to look in case law and see.
Take your time. There's no
Yes, Judge.
Yeah, absolutely. There's no rush here. I mean, we got,
Yes, Judge, and I respect 5 or 10 minutes and just to look at.
Absolutely.
Yes,
Take your
Judge.
time. Okay. once and for all.
Yes, Judge. And after reviewing the video and reading case law where there's a case Duncan Telvey State where they describe it as essentially shutting down, even we looked at it, we don't see that here.
Okay, I'm gonna find no problem.
Yes, Judge.
All right.
Yes, Judge.
All right,
Your Honor.
good job.
Thank you, thank you.
And I'm gonna tell you, look, from what I read, I was looking at case law as well too, and it said the gross deviation is such that like, there was a guy who had a trailer, right? Who didn't put chains on the trailer detached, it was a homemade trailer, it detached and it killed someone. That's a gross
That's why I
deviation, you know what I
posted the
mean?
video and it was just
Yeah.
very brief. Yes, Judge.
We have enough cases.
Yes, Judge.
Thank you, Your Honor.
Yeah, PC for Samuel Duto.
Okay, sure. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases, he got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven and the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and identified and asked for his identification. The suspected charge is theft of a service under penal code.
Oh, come on, they charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the,
I know, but that's the contact to get to him.
yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what, so they go up to him, they start talking to him, they,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he said his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
Defendant had outstanding warrants and was placed in custody.
Right, they was.
He was charging his phone.
what do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Talk to Pavel, let's see.
Judge, we would, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good, he's not going anywhere, right, on the theft,
I mean,
so.
when he's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest, I mean, that's.
Do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
Because it might happen anyways.
I
You know
wanted
what I mean?
time served. I wanted the time served. He offered, he would have to do 24 more days.
I'm okay with that, or I'm okay with whatever you want.
Okay.
It's up to you guys.
Yes, Your Honor. I'll always defer to Pavel with things. After 90 days, depends once time served.
Yes.
Okay, and I'm totally fine with that too.
Okay, thank you. All right.
Thank you.
We'll came up. Thank you.
Hey, Alan. Okay, so first we have, is this, that's Rivera and Soto?
With the D,
Oh,
I
Duarte,
can't- I know
right.
I mispronounced it, so. Pronounce it one more time?
Duto.
Duto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with two cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the.
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it, you know? Most times people plead to the theft case and it really hoses them. Because then you're looking at, you know, federal, or not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served, 18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering into these agreements.
You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? What time are we looking at on Rivera? 21/7? Okay, so it's 21 days in jail. Credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs.
As we wrap up today's docket, there's something important to take away from these hearings, something that often gets overlooked when we talk about justice, policing, or the criminal courts. What you saw today wasn't dramatic lawyering or courtroom theatrics. It wasn't a battle of personalities. It was something much more fundamental, the constitutional promise that the government must justify its power before it can take away someone's liberty. In every single case we watched, the judge applied the same simple, unwavering rule. The state must prove exactly what the law requires, no more and no less. And when the evidence didn't fit the statute, whether because there was no reported pain, no interference, or no criminal negligence, the judge didn't improvise, speculate, or stretch the facts. He honored the boundary. And those boundaries matter. They protect the innocent, they restrain the government, and they ensure that criminal charges are grounded in facts, not fear, assumption, or convenience. It's easy to look at these cases and think, these are just misdemeanors. Why does all of this matter so much? But for the person standing in that courtroom facing jail, fines, or a criminal record that could follow them for life, there is no such thing as just a misdemeanor. Every case is a turning point. Every decision has consequences. And every probable cause review is an opportunity for the justice system either to uphold fairness or to let it slip. Today we saw what fairness looks like when it's applied meticulously. We saw what happens when a judge slows down and asks the hard questions. And we saw how quickly weak cases fall apart when held up against the actual law. If you believe this kind of transparency matters, stick with us. More real hearings, more breakdowns, and more insight are coming soon.